Welcome to Hull and Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening to episode 166 of our podcast on Tuesday, May 26th, 2009.
Hi, Suzana.
Hi, Ian. How are you today?
I'm doing great, thank you.
That's good.
So, one of the things that we wanted to work through today and talk a little bit more about was the development of, we have always try to encourage our clients to stay out of the litigation process because of the uncertainty. And one of the great uncertainties is what we call interlocutory or injunctions or motions or mid-steps throughout the process. And we thought we would try to illustrate our point to show how crazy litigation can get and how some of the tangents it can turn without an ability to predict, by talking a little bit about the kinds of motions that are brought on off often, or some that aren't brought often but can create a whole new chain of events in terms of costs and difficulties when you're trying to resolve the problem in the litigated court format.
And I think, Ian, this is a good discussion to have because it helps us explain as lawyers why it is that when clients say, well, how much will this will challenge cost, that we give them a range from A to B that, you know, it's got a whole bunch of unknowns in between, because some litigation can be run quite smoothly, other litigation, you never know what's going to arise. And the other intangible, of course, is you don't know how the other side or the other sides are going to respond in kind to any of these steps as well. So that's where our uncertainty in terms of budgets for litigation come in. And some of these motions that we'll discuss will be illustrative of that.
Absolutely, because in some ways, when people get into embroiled in litigation, it becomes a little bit of, well, one person does something and the other person wants to fight back and do something else, and it becomes strategic. And a classic example is when you get into scenarios where someone will say, well, look, insufficient disclosure has been provided. For example, you haven't provided me with all the historic wills or the notes relating to the wills. And then the other side will come out with a motion saying, well, insufficient information is provided in respect of your claim. You haven't showed us any financial interest you have. You haven't showed us any of the corporate records that might be relevant or something like that. So that's just an easy illustration, and we'll talk about particulars now, but that's an easy illustration of how, from a strategic standpoint, these things explode. And each motion is literally tens of thousands of dollars, regardless of how we want to do it. And so you put the strategic overlay onto this and then talk about some of the easy hot buttons that people can press.
And we talked during our last podcast about one of the easiest examples of a motion that can arise, and that is during a discovery process. If questions are asked and for whatever reason counsel decides that they're not going to answer questions, then we've got to bring a motion to get those answers from the parties who've been examined, and that will ultimately depend upon a determination by a judge as to relevance, whether or not the question is one that is relevant to the litigation, whether it was properly asked, and if it has to be answered.
So you can see that example alone, it demonstrates just how crazy things can get, because what you're ultimately doing is, say you say to the client, to the witness on the other side, as you're learning about your case, to that witness who is just alleging that the will is invalid or something, and you say, well, you know, on what facts do you rely on in respect of that allegation? And for some reason their lawyer decides that they want to, for strategic reasons, be difficult, and they say that's not relevant. So you can't even scratch the surface of your claim without going back to court to get a motion to release that information and to release the witness, so to speak. And all of those steps are literally tens of thousands of dollars. And really, what the thing that's most upsetting and disturbing for most clients is that a lot of these interlocutory, these motions, tend to be sort of based on strategic steps as opposed to economic or really how important they are and not important they are. And what, you know, when we unleash people into litigation, we forget that there's going to be an overlay, a tremendous overlay of strategic steps that people are going to take, motivated maybe to beat up the other side, maybe to flush out their case, maybe just legitimately to understand their case better. But that uncertainty is obviously there, and who knows, one party may react differently than other parties.
Another situation where, again, you can't predict or control is when you have a lawyer that you want to examine or their file that you would like to obtain for instance, a will challenge. The lawyer's evidence is going to be quite crucial. And many times in those situations, the lawyer will get counsel. Counsel will insist on a motion to be brought to waive solicitor-client privilege, to compel the individual to produce their file, and to compel them to attend at discoveries as well. Again, another step that, it seems self-evident, seems very important, that information, but we've got to jump through a couple hoops in order to get that evidence properly before the court.
Absolutely. And one of the things that we find really upsetting and frustrating is anybody who's on a fiduciary role, is in a fiduciary role, an executor or trustee, when they behave arrogantly, we sometimes have to run to court to, again, get a judge to say you can't behave that way. And an easy example there is where a fiduciary or a trustee will not disclose the wills, or more importantly, won't disclose the assets. And you have to bring a separate motion for disclosure of the assets alone. Before you even get into the fight, you're into a motion on a procedural point because that trustee is acting either arrogantly or is acting strategically. And they look at this and say, well, look, they're not going to have the energy or the money and the wherewithal to really push me on this, so let's just ignore them, or let's act arrogantly and say you're not entitled to it, and make them go to court. And by the time they get to court, maybe they settle at the courtroom door, maybe they don't, whatever. They have created what is really a strategic and sometimes, in some cases, is a bit of a bully tactic, but can be effective because of the economics of the process.
And also, ultimately as well, many times we've seen situations where we'll actually litigate the issue, that motion, and then a judge will reserve costs, rather than taking the opportunity to possibly penalize the party that maybe they view as having acted improperly, or certainly that we would have viewed as acting improperly, and then they don't make that cost order. They'll save it for the end of the day, which is, of course, a reasonable award to make by a judge, but litigants and clients in particular can be quite upset by that result, I think.
Well, it's all a part of the unknown, and whenever you step into the process, if you're going to step into it, the more educated you are about the process, the better off you are. Just to simply say to a lawyer, well, we're going to write a blank check and you do whatever you have to do and whatever you think should be done, is one approach, but most people wouldn't renovate their house on that basis.
For sure.
So you're going to want to be active, you're going to want to make those strategic calls. Well, how important is that? How unimportant is it in the whole scheme of things? And maybe you are trying to look strong and powerful in what is a contentious gladiator-like relationship. All of those are legitimate motivations, but people should, it seems to me, our clients, we really need to make sure they understand going into this, A, as you say, we don't have control over the agenda, and B, sometimes these motions and things like that can be appropriate, and are the sincere and legitimate inquiry is being made or being sought by the court order. So, as we work through that issue, I think it's because the theme here we've been trying to do is talk about what we're going to get ourselves into in litigation, but instead of just saying with a blanket, it just costs a lot. This is part of our attempt anyway to illustrate what it does cost a lot and how much effort that's going to involve in the process and in some of the uncertainties that come with it. So that's the motions, the interlocutory, and the mid-steps that we thought we'd walk through today.
Okay.
So in our next podcast, we'll finish off some of our thoughts on costs, as I say, not on the sort of broad scale, but on the sort of detailed analysis approach. So thank you very much for joining us this week.
Thanks very much to you, Ian, as well.
You've been listening to Hull and Estate and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast you have been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.